Net neutrality is the principle where your internet service providers, your ISPs, such as Comcast, AT&T, and Verizon, must provide equal access to all internet content without favoring or blocking particular products or websites. As internet users, net neutrality guarantees us the ability to watch something like the Evian Dancing Babies at equal speed, quality, and availability as the most hated video on the internet. As a small company or an entrepreneur, net neutrality establishes a fair opportunity for you to achieve market growth and recognition. This principle is what allowed for the success of Facebook. Net neutrality gave Facebook and the former market leader MySpace equal grounds to compete for and obtain market share. Because of these foundations, Facebook was able to challenge the previous success of MySpace and eventually acquire their current market dominance. Equal access and opportunity both sound pretty good, so why is net neutrality even a debate at all? Well, the answer to that question continuously leads us back to your one and only internet service providers. ISPs are for the disbandment of net neutrality, arguing that bandwidth-heavy web services like video streaming and content downloads financially restrict their ability to improve their current networks. You see, these companies claim that if they can charge service providers such as Netflix and Google for superior availability and superior quality of their IP addresses, then the ISPs could then invest into upgrading their services, expanding to more rural areas, and giving overall faster, higher quality access to what people have the most demand for. Proportionality between cost and quality of service is the argument commonly known as the fast lane theory. A positive outcome of giving ISPs more control is that it would allow for better regulation of illegal and age-restricted internet content such as torrent downloads and underage pornography. Debate on net neutrality has been going on for quite a long time, and its laws and regulations vary from one country to the next. Net neutrality was first introduced to the Canadian legal system in May 2009 with the proposition of amendment to the Telecommunications Act. These laws, under Bill C-398, were then welcomed into Canadian law on January 25, 2011. Canada has adopted these laws and as of yet have not had any serious considerations toward changing them. However, the US is in a very different situation. The FCC has been recently mandated to repeal any legislation pertaining to net neutrality. Although it is officially unclear as to why the government is supporting this repeal, comedy host John Oliver from the Last Week Tonight Show suggests that lobbying influence is a major player. And this is what he had to say.
These companies have Washington in their pockets to a conveniently almost unbelievable degree.
Comcast has spent $18,810,000 in lobbying last year. That's more than any other company except for defense contractor Northrop Grumman.
So just to be clear, the ranking of who buys government influence is number 1, military-industrial complex, and number 2, the provider of lizard-lick towing.
The history of this debate began after the Telecommunications Act of 1996 was implemented to prevent ISPs from throttling internet connections for specific IP addresses. On September 23, 2005, the FCC issued an internet policy statement that set out net neutrality rules for ISPs. This statement emphasized the importance of internet diversity and maintaining a free market. In September of 2007, Comcast was accused of interfering with BitTorrent traffic on its network. However, the company denied these claims, saying that they merely delayed the server. This event initiated the involvement of public interest groups, Public Knowledge, and Free Press. On November 1, 2007, these groups submitted a formal request to the FCC to investigate Comcast BitTorrent blocking. After opening an investigation in January 2008 and finding Comcast guilty of the claim 7 months later, the FCC issued an order to Comcast to stop their current discrimination. On September 4, 2008, Comcast appealed the FCC's order to the D.C. Circuit Court of Appeals. The D.C. Circuit becomes involved on April 6, 2010 with the rejection of the FCC's use of Title I ancillary authority in punishing Comcast. This event rose questions about the FCC's authority in issuing net neutrality rules. However, by December 21, 2010, the FCC finds their authority and issues the Open Internet Order. This order was published in the Federal Register on September 23, 2011, and was set to take effect on November 20, 2011. The questions that the D.C. Circuit brought up regarding FCC authority began what some critics call the stage of rebellion for ISPs. A standout case concerned AT&T blocking a high-bandwidth app called FaceTime on iPhones and iPads. Public Knowledge and Free Press recognized this violation and successfully got AT&T to unblock the app. On January 14, 2014, the DC Circuit overturns the FCC's Open Internet rules. 36 days later, the FCC announced its decision to explore its ability to create net neutrality regulations in wake of the DC Circuit's decision. The FCC considered its options under Section 706 of the Telecommunications Act by looking into the use of fast and slow lanes. Publicity of this idea, alongside a concurrent investigation finding Netflix to be paying Comcast and Verizon to improve video quality issues, triggered the introduction of the Competition and Consumer Choice Act. This act outlines the ban of internet fast lanes and stops paid prioritization. The frustrating back-and-forth nature of this issue between the DC Circuit, public interest groups, and ISPs motivated the FCC to involve the public. The FCC launched an online comment basis for opinions regarding net neutrality. This server received 3.7 million comments, only 1% of which were clearly opposed to the issue. President Obama and the chairman of the FCC endorsed Title II net neutrality rules, and they are soon passed and entered within the Federal Register on March 12, 2015.
Abandoning these principles would threaten to end the internet as we know it. That's why I'm laying out a plan to keep the internet free and open. And that's why I'm urging the Federal Communications Commission to do everything they can to protect net neutrality for everyone.
On April 26, 2017, new FCC Chairman Pai announces a plan to roll back net neutrality rules. The FCC voted in favor of this rollback.
The question that we at the FCC must answer is what policies will give the American people what they want? And that question has been the subject of a fierce public debate. And this afternoon, a new chapter of that debate will begin.
In a nutshell, the U.S. net neutrality debate is and has been an extensively dragged-out discussion that began with the establishment of net neutrality legislation and has progressed back and forth to the removal today. Anybody aware of the U.S. Bill of Rights, or the UDHR, are probably wondering, what about freedom of speech and freedom of expression? Well, these mentions were actually some of the first to come up in the defense for net neutrality. However, due to the virtual and online nature of this issue, many complications arose with how these laws and rights actually transpose from the physical world into cyberspace. Back in the mid-1900s, the US was one of the 68 countries to vote in favor of the UDHR. Under Article 19 of this document, everybody has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. The U.S. is also a signatory party to the International Covenant on Civil and Political Rights. Article 19 of this document states that 1. Everybody shall have the right to hold opinions without interference, and 2. Everybody shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in written or in print, in the form of art, or through any other media of his choice. Withholding the same principles as both the previous documents, the U.S. Bill of Rights has mentions to recurring arguments within this debate under Amendment 1 and Article 5. Amendment 1 states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. Similarly, within Article 5 it is stated that no person shall be deprived of life, liberty, or property without due process of law. Together, these documents outline the legal obligation of the U.S. to enforce freedom of speech, freedom of expression, and the right to own property. Previously, the U.S. has supported these laws in cases of protest, public news, etc. But the growing age of our virtual world and its fuse with our physical environment is currently forcing the law to consider how it will be applied to the internet. The question that the court is faced with is, should one be guaranteed the rights of a person whilst on a server that has the ability to conceal and in so remove one's identity? Through equating the physical and virtual environment, the eyes of the law might be able to reconsider the legality of the recent repeal of net neutrality regulation. The UNESCO 1999 draft on cyberspace law outlines a proposition regarding how current law should be reflected into the virtual world. This document outlines 5 main principles that generally support the inclusion of cyberspace into our legally enforced environment. Essentially, this document creates the same rights and laws within the physical and virtual world. The UNESCO 1999 draft on cyberspace law is merely a draft, without signatories or enforcement, and therefore it cannot be significantly applied into enforceable law. Saying this, however, a precedent case between Renault and American Civil Liberties Union seemed to treat cyberspace as one with the physical world. This precedent case discusses the nature of the Internet as a public, private, and commercial sphere relative to the District and Supreme Court's judgment on the Communication Decency Act. When looking at the proposed content restriction of online speech set out in the CDA, the Court takes lead with the establishment that Internet communication is entitled to the First Amendment protection. Thus, First Amendment protection applies with the same force in the virtual world as it does in print media or in the physical public sphere. In this precedent case, the Court acknowledges that cyberspace undeniably reflects some form of geography. Chat rooms and websites, for example, exist as fixed locations on the Internet. The Court continues on to state that the Internet is both a means of public, private, and commercial communication that has encompassed both systems and life world. Through the consideration of this precedent ruling, the Court may reconsider the relevance of the UDHR, the International Covenant on Civil and Political Rights, and the U.S. Bill of Rights with regards to net neutrality regulation.